Hi, this is Advocate Prashant Kanha. I practice in Honorable Supreme Court of India. In this video, I am going to talk about quashing of a criminal case against accused person and the limitations of the High Court while exercising the jurisdiction of quashing of the criminal case. So first of all, let us understand that when does a criminal law comes into motion against an accused person. The first process is direct process in which an FIR or a first information report is registered by the police and the police has the power to investigate the matter. Once police has the power to investigate the matter, it will have the power to arrest also the accused person if certain requirements under the law are met. So supposedly if the offense is punishable by less than 7 years, then the police has a process to follow, that it will have to issue notice and it will have to give reasons that why it wants to arrest the person or the accused person. While in cases where the offense is punishable by more than 7 years, in that the police does not have to record the reasons or does not have to give notice to the accused person before arresting him. So, and the other process in which the criminal law is set into motion is by filing a criminal complaint against a person directly before the court of magistrate, where the magistrate evaluates the issue or the matter and then issues summon to the accused person. And once this summon is issued, the accused person has the duty to get bail in the matter. And it is again the discretion of the magistrate to either grant the bail or does not grant the bail. So in these two circumstances, one is arrest and one is summon and sending you into judicial custody by the magistrate. So in these two circumstances, in both of these circumstances, the personal liberty of the accused person is going to be jeopardized. So the law has provided, or there is a procedure, that if you think that the FIR where your version has not been taken yet and only the version of the accused has been taken, only the version of the complainant or the informant has been taken, and before the magistrate also one-sided proceeding has happened. In both these circumstances, there is a remedy available to the accused person, that he can approach the High Court directly against these material, against the FIR or the complaint case, and get the matter quashed by the High Court. Quashing means cancellation of the entire criminal case. Once the matter is filed, you have to bring your case within the scope or the grounds that are given in a judgment of the Honorable Supreme Court of India, that is State of Haryana versus Bhajanlal. In this case, Supreme Court has given 7 grounds on which, if those 7 grounds are met by the facts and circumstances of the case, then criminal case can be quashed. Various grounds which are given therein are that from the reading of the FIR, a cognizable offense is not made out, or if the accusation are so absurd that it does not constitute any offense, or if it is proven that the case that has been filed is nothing but an attempt of vengeance, or when the proceedings are barred by any legal formality or some legal formality has not been followed, etc., etc. I have given the 7 grounds in the description below. You can go through it, or you can Google the grounds of quashing in the state of Haryana versus Bhajanlal. So if you think, or your advocate suggests that your case comes within the ambit of the grounds of state of Haryana versus Bhajanlal, then you should definitely approach the Honorable High Court for getting your case quashed. Now, what is the interim relief that a person can, or accused person can get once he approaches the Honorable High Court for quashing of the matter? In quashing petition, if the High Court is primarily satisfied that there is a case made out by him on the basis of the material brought by him before the court, it has the power to grant any relief. However, reasons have to be recorded for that. And however, granting any kind of relief which restricts the arrest of the person and directs the police to investigate the matter without arresting the accused person, that should be very rare in very rarest of the rare matter, as has been held by the Honorable Supreme Court in Niharika Industries matter. Niharika Industries case was there, in which the Supreme Court has held that arrest stay should not be granted, especially while disposing of the writ petition as a relief to the person. Means sometimes high courts pass an order that person would not be arrested, but the writ petition is disposed of, or the quashing petition is disposed of, and he will not be arrested until and unless charge sheet is filed in the matter. So that kind of practice has been specifically restrained by the Supreme Court, giving the reason that there is a formal procedure for staying the arrest or stopping the police from arresting a person, and that is the anticipatory bail. And in anticipatory bail, there is a certain procedure and certain grounds and certain procedural formalities have been given for granting anticipatory bail. So that process should be adopted and not an arrest order from through Article 226 by filing a quashing of petition. The Supreme Court highly deprecates this practice of granting arrest stay in these matters, and if in case you are a complainant and you think that a wrong arrest stay has been granted by the High Court, then you can definitely approach the Honorable Supreme Court on the lines of the judgment of the Niharika Industries by the Honorable Supreme Court of India. The full citation of the matter is given in the description box below. So this is about this quashing and the interim stay, that interim relief that can be granted by the High Court and limitations there. Thank you so much for watching this video. If you anyhow get benefited by this video, please do like the video.